Big USCIS news just dropped and it could change everything for green card applicants before this year ends. By the end of November 2025, the U.S. Citizenship and Immigration Services is preparing to update the green card eligibility rules, and the details are shaking the entire immigrant community. Whether you're applying through a family petition, a job offer, or adjustment of status, the rules you thought you knew might not apply anymore. Here's the reality. USCIS isn't just tweaking small details, they're reshaping who qualifies and how applications are judged. From income verification to background checks, from proof of residence to new documentation standards, this upcoming rule is being called one of the biggest eligibility shifts in a decade. People who once easily qualified could now face extra screenings, higher financial thresholds, or even rejections if they fail to meet the new standards. And the most shocking part? These changes are already in motion. Policy memos, internal updates, and federal notices show that the new framework could take effect right before December 2025, giving applicants barely any time to react. That's why immigration lawyers and advocacy groups are urging everyone, especially those planning to apply soon, to move fast, double-check every document, and understand the upcoming criteria now rather than later. If you're in the U.S. on a work visa, student visa, or family-based status and you're aiming for permanent residency, you cannot afford to miss this. The smallest misunderstanding could mean months of delay or worse, a complete denial. But don't worry, in this video, we'll go through exactly what's changing, how it could impact you, and what smart steps you can take right now to protect your green card process before the rule officially takes effect. Stay tuned till the very end, and before we dive in, make sure to like this video, subscribe, and turn on notifications, because every update I share could make the difference between getting approved or starting over from zero. Alright, let's dive straight into what's really happening. The USCIS has officially confirmed that new green card eligibility changes are set to take effect by the end of November 2025, and this isn't just another small rule adjustment or procedural update. It's part of a much larger effort by the U.S. government to reshape immigration pathways to make the system more secure, self-sufficient, and merit-driven. That's the official wording. But what does it really mean for everyday applicants, families waiting to reunite, and workers dreaming of long-term residency? Let's break it down step by step, in plain English, because the implications here are serious, and time is already running out. First, let's talk about what sparked this change. Over the past few years, USCIS has been under intense pressure to tighten eligibility standards, streamline processing, and address backlogs that stretch millions of applications deep. But behind the scenes, there's also been growing concern about what officials call the sustainability of the immigration system. In simpler terms, the government wants to ensure that every new green card holder is financially stable, law-abiding, and capable of contributing economically without depending on public support. That's not a new idea, but the way they're now planning to measure it is completely different. Under the new rule, financial independence becomes one of the core pillars of eligibility. That means more weight will be placed on income history, employment verification, and assets. For instance, an applicant who previously only needed to meet a minimum income requirement based on the federal poverty line may now have to demonstrate stronger financial standing, not just for themselves but potentially for their entire household. Sponsors may be required to provide deeper financial records, tax history over longer periods, and even proof of stable assets. It's not about discrimination, officials say, it's about ensuring that every green card recipient can integrate smoothly into the American economy. But the catch is that this change could make it harder for low-income families or individuals in transition, such as new graduates, entry-level workers, or dependents, to qualify as easily as before. Imagine a young couple trying to adjust their status through marriage, or a skilled worker who just started a new job after completing their OPT. They might suddenly find themselves asked for higher proof of income or additional co-sponsors. Immigration attorneys are already warning that if applicants don't meet these elevated financial thresholds, their cases could face delays, requests for evidence, RFEs, or even outright denials once the rule kicks in. Next, the new eligibility framework will also focus heavily on residency consistency, meaning USCIS will start scrutinizing how long and how steadily you've been physically present in the U.S. This is meant to prevent cases where applicants travel frequently or spend extended periods abroad, which officials claim complicates the verification of intent to reside permanently. Now, while the law already requires applicants to maintain residence, the enforcement under this rule could become much stricter. A few months outside the US might not have mattered before, but in 2025, it could raise red flags and trigger additional questioning about your commitment to stay long-term. Another major shift comes with background screening and admissibility reviews. The agency is expected to enhance coordination with federal and state systems to review applicants' records more deeply, including tax compliance, criminal background, and even social media footprints in certain cases. This isn't about snooping for fun, it's part of a broader strategy to ensure applicants meet what USCIS calls modern security and integrity standards. So if you've ever had minor legal issues, unreported income, or inconsistencies in your immigration paperwork, those could carry more weight than ever before. Let's be clear, this rule doesn't just affect new applicants. If you've already filed your Form I-485 or are waiting for your priority date to become current, you could still be affected, especially if USCIS requests additional information or applies the new guidelines retroactively during your adjudication. This is why immigration experts are urging everyone to prepare early, because once the rule takes effect, you might not have the luxury of time to fix mistakes or update documents. Now, let's talk about why November 2025 is such a critical month. According to insider reports and government scheduling patterns, this timeline aligns with the end of the fiscal year adjustment period, a time when USCIS typically implements new policy frameworks. They've done this before with other major reforms, such as fee changes and the introduction of online processing systems. So it's not a random date, it's strategic. By late November, they expect to have finalized the framework, trained adjudicators under the new guidance, and started applying these standards to both new and pending cases. For many families, this could mean a sudden rush to file before the cutoff. Immigration offices across the country might see an influx of applications between now and November, and history tells us what happens when that occurs. Backlogs, long processing times, overloaded service centers. If you remember what happened in 2020 when new affidavit of support rules were introduced, thousands of applicants tried to beat the deadline and flooded USCIS with last-minute filings. The result? Months of delays. That could very well happen again. Let's also address another part of the rule that hasn't received enough attention: the evaluation of educational background and job relevance. USCIS is expected to tighten how it evaluates the connection between an applicant's skills, education, and employment offers. For employment-based green cards, this means officers may look closer at whether your job truly aligns with your qualifications and whether the employer can prove your role is essential. In other words, if you're working in a field that doesn't directly match your education or experience, your petition might face extra scrutiny. This change reflects a growing trend of aligning immigration policy with labor market needs, prioritizing applicants who can fill critical gaps in the economy. But even for family-based applicants, this could have indirect consequences. The focus on economic self-sufficiency might push USCIS to look more critically at household income and employment stability, even if your sponsor technically meets the legal minimum. It's not just about the numbers anymore, it's about overall financial reliability. That's why many attorneys now recommend that applicants strengthen their financial documentation, include pay stubs, bank records, and even letters from employers confirming long-term employment security. So how does this affect you if you're currently living in the US and planning to adjust your status soon? The short answer: you need to act quickly and strategically. If you're eligible now, don't delay. Get your paperwork ready, double-check your forms, and file before the rule becomes official. Because once it does, you might find yourself facing requirements that you can no longer meet. If you're overseas waiting for consular processing, the same urgency applies. These new rules could change how consular officers interpret your eligibility, and they'll be required to follow USCIS's updated guidelines. Let's talk about something many people overlook: the emotional toll these changes can cause. Immigration isn't just a legal process, it's a life process. Families spend years saving, waiting, and hoping for that one approval notice that changes everything. So when the rules shift suddenly, it creates confusion, fear, and uncertainty. That's why staying informed is so critical. Watching videos like this isn't just about news, it's about preparation, protection, and peace of mind. You don't want to be one of the thousands of people who wake up in December 2025 to find that their dream of permanent residency is suddenly out of reach because they didn't act fast enough. Now, let's get real for a moment. Every time USCIS introduces a new rule, There's always a wave of misinformation, social media posts claiming the system is shutting down, rumors about mass denials, and fake expert advice floating around. Don't fall for it. Always rely on official USCIS announcements, verified immigration attorneys, or reliable community organizations that track policy updates. In this video, we're committed to breaking things down accurately, so you can make decisions based on facts, not fear. Another point worth noting is how this rule might interact with public charge guidelines. The concept of a public charge, meaning someone likely to depend on government assistance, has been controversial for years. The Biden administration rolled back the stricter version introduced in 2019, but with this new rule, certain aspects might resurface in a softer, modernized form. Instead of labeling applicants as public charges outright, USCIS might assess their financial independence through new scoring criteria, for instance, giving higher priority to applicants with stable employment, savings, or educational credentials. It's a subtler way of achieving the same policy goal, promoting self-reliance. And remember, when USCIS changes eligibility rules, it doesn't just affect one group. It sends ripple effects across all visa categories, from student visas that lead to status adjustment, to employment petitions filed by U.S. companies, and even humanitarian cases like asylum seekers hoping to transition to green cards later on. This is why immigration experts say we're entering a reset era where the system prioritizes applicants who demonstrate long-term contribution potential. If you're someone who's been putting off your green card process, maybe you were waiting for a promotion, saving more money, or just feeling unsure, this is your sign to move. The window is narrowing, and every week closer to November means more uncertainty. Don't assume you'll have the same chance next year, you might not. Gather your documents, consult a licensed immigration attorney, and take action while the current rules still apply. One of the biggest mistakes applicants make is waiting until USCIS officially publishes the rule in the Federal Register. By that point, it's usually too late to adjust your strategy. The best move is to get ahead, because once the new rule takes effect, every form, checklist, and interview process will follow the updated guidance immediately. There will be no grace period, no soft transition, and no exceptions for those who didn't know. That's why the smartest thing you can do right now is prepare as if the rule is already active. Now, let's talk about what might happen after the rule goes live. Based on past rollouts, we can expect a few things. First, confusion both among applicants and even within USCIS offices. Officers will be learning the new framework, which means inconsistent decisions are likely in the early weeks. Some cases might get approved quickly, others delayed, and a few denied for unclear reasons. That's normal during transitions. But those who have strong, well-documented applications tend to fare best because officers have less room to question them. So documentation is your best defense. Second, we might see an increase in requests for evidence, RFEs, those letters USCIS sends asking for extra proof. Under the new rule, they might ask for updated tax records, additional sponsor verification, or new forms of proof showing you meet revised standards. Treat every RFE seriously. Respond quickly, thoroughly, and professionally. Ignoring or rushing these can lead to denials, and refiling later could mean starting all over under stricter conditions. Lastly, we might see ripple effects on citizenship applications in the long run. If eligibility standards for green cards become tougher, it could mean fewer people reaching the stage of naturalization in the coming years. That's why it's important not just for applicants but also for policymakers and community leaders to monitor how this plays out. Now, I want you to really think about this. How long have you been planning your immigration journey? How many sacrifices have you made to get here? Every form, every fee, every waiting period, it's all led to this moment. Don't let bureaucracy or timing take it away. These new rules are a reminder that immigration isn't static, it's constantly evolving. Those who stay informed and act strategically survive these shifts. Those who don't often get left behind, confused and frustrated. So here's what you can do right now. Stay connected to reliable updates, watch the official USCIS page for announcements, and don't rely on rumors. In the next few months, we'll see draft versions of this rule published publicly. When that happens, I'll break down every single clause from income thresholds to new eligibility categories right here on this channel. So if you haven't yet, hit that like button, subscribe, and turn on notifications right now, because these next few months could decide your immigration future. The road to a green card has always been filled with challenges: long waits, complex paperwork, and shifting policies. But with awareness and preparation, you can still navigate it successfully. The November 2025 change might look like an obstacle, but it's also a chance to strengthen your application and secure your future in the US on solid footing. Don't let fear control your next move, let information guide it. By the end of this video, you'll know exactly where you stand, what's coming, and how to prepare smartly. So keep watching till the very end, because the more you understand this rule, the better your chances of success when November arrives. And remember, immigration favors the prepared. So get ready, stay alert, and always stay one step ahead. Like this video, share it with anyone who's planning to apply, and let's make sure our entire community knows what's coming before it's too late.